Let's bring you some other news now. The Constitutional Court has upheld a ruling by the Western Cape High Court that found parts of South Africa's refugee laws unconstitutional. At the centre of the case are rules that allowed asylum applications to be rejected on procedural grounds. Rights groups say these laws have made it difficult for some to access the refugee system and to have their claims heard. Newsroom Africa's Ntokozo Khumalo is tracking that story. She joins us now live. So the court agreeing essentially, Ntokozo, with the High Court decision.
Good morning again, Michelle, and to the viewers. Absolutely, that is the decision that Justice Majid delivered this morning, on top of course, giving the Home Affairs Council a little bit of a lashing when it comes to some of the legal arguments that it presented to the courts, but indeed a win for the rights groups and those sections that were under question, being section 4.1, 4.1H, 4.1I and 21.1B of the Refugees Act 130 of 1998, and then regulations 8.1CI, 8.2, 8.3 and 8.4 of the refugee regulations that the courts then declared was invalid or unconstitutionally invalid, upholding that order that was made by the High Court in the Western Cape in 2025. This litigation going back about 2 years when Scarabina Brini raised that issue, arguing that it makes access to the asylum system for vulnerable people near impossible, and that they get turned back from being able to apply for asylum based on those procedural failures as opposed to merits. And those procedural failures, Michelle, including then people entering the country without documentation or taking too long to apply for that asylum status. So the question is, what next when it comes to then those provisions within the Act as well as the regulation, and how long it will take for then the states to be able to make those amendments, or will we see more court action and litigation come about, but also what it means for those foreign nationals currently looking to either have that asylum status as they face then that deportation or repatriation back to their home countries. But of particular concern in this decision, that was a unanimous decision, Michelle, is what those provisions mean for young children who may have entered the country without documentation, but placing those issues on their parents and not on the children. Let's hear what the justice had to say there.
The court also accepts that the challenged provisions have serious consequences for children. Where a child's asylum claim is tied to that of a parent, the child may be excluded from the asylum system because of the parent's procedural non-compliance. This occurs without an individual assessment of the child's circumstances and without proper regards to the child's best interests, contrary to the dictates of Section 28 of the Constitution. For these reasons, then, this court holds that sections 4.1F, 4.1H, 4.1 Roman 1 and 21.1 capital B of the Refugees Act are inconsistent with the Constitution and invalid. The High Court's order of constitutional invalidity must therefore be confirmed. As to remedy, the respondents did not seek a suspension of the declaration of invalidity or any reading in order. The court therefore confirms the declaration of invalidity.
So, Michelle, I mentioned the justice also lamenting the Department of Home Affairs Council and the legal arguments that it presented to the court on why those provisions are important to safeguarding the country's borders as well as its immigration stance. And that was around legal arguments stating that some foreign nationals or countries actually perpetuate crime crime, including human trafficking in the country. So now that the department has lost this particular case, they will then carry the cost of the litigation. But let's listen then on the lamenting that it got when it comes to then some of its legal arguments that it presented over the past 2 years.
This court holds that the respondents must pay the applicants' costs. The respondents litigated poorly in relation to their purported challenge to the High Court's order declaring the regulations invalid. Their failure to follow the proper procedure, their delay, and their failure to seek condonation are matters of serious concern. The court further expresses concern about sweeping and unsupported assertions made during argument regarding Afghani and Bangladeshi nationals' involvement in human trafficking in South Africa. The court holds that such assertions made without an evidentiary foundation undermine the integrity of the state's case and risk promoting prejudicial narratives about refugees and asylum seekers. This conduct is deserving of strong deprecation.
All right, Ntokozo Khumalo, live to us there at the Constitutional Court.